Welcome, everyone. Welcome to the webinar this morning. We're just letting everybody migrate in from the waiting room into the presentation room. We'll get started in just a minute. Just letting everybody migrate in from the waiting room to the presentation room. We're going to give people one more minute, and then we'll get started. About 30 more seconds and we'll get started. Welcome, everyone. Okay, hello everyone, and welcome to Domestic Violence During COVID-19 and Lockdown Q&As, brought to you by Domain Computer Services. I'm Kate Conroy, Vice President of Strategic Partnerships for the New Jersey Business and Industry Association. With us today is Roseanne DeTorres of DeTorres DeGeorge Family Law. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. If you just can't wait, you can download them right now from the Handouts tab. I'd also like to draw your attention to the Questions tab. Roseanne would be happy to take your questions, so get them in as they come to you via the Questions chat box. One last thing, it's definitely been getting better, but we've still been noticing people having audio and visual issues with GoToWebinar as they struggle to keep up with the extra video conferencing going on right now. If you have any trouble viewing or hearing during this presentation, don't forget you will automatically be receiving a recording within 24 hours. So if you have to sign out and watch the recording, you won't miss a thing. And so now, without further ado, Roseanne, please take us away.
Thank you so much, Kate. I should be receiving there it is, show my screen. I'm going to start here. Good morning, everybody. Thank you for being here. Thank you for taking the time to be here on this lovely Thursday morning. I'm going to take you through what domestic violence is during COVID lockdown and generally speaking, what domestic violence is. We're going to cover a lot of ground, so stay with me. Who am I? I'm Roseanne DeTorres. I own and manage a small family law firm. We have offices in Morristown and beautiful Hunterdon County, New Jersey. I have 32 years experience in family law and spent plenty of time in the domestic violence arena and tried many, literally hundreds of cases in domestic violence. I have a specialty certification in family law, so I am considered an expert and represent both sides of the domestic violence case, both plaintiffs and defendants, and I've always been a very dedicated advocate for victims. So here's what we're going to cover today. I'm going to help you define what domestic violence is. I'm going to talk to you about the statute or the law on domestic violence. We're going to talk about the difference between temporary restraining orders and final restraining orders. If you have to go to a domestic violence trial, what that might look like. What does a judge consider when evaluating whether to give you a final restraining order? We're going to talk a little bit about testimony and evidence, how we present a case in the domestic violence arena, and what kind of relief can be granted under the FRO, and what might happen if the final restraining order is actually denied. So please ask questions. I want this to be as interactive as possible. Kate's going to give me a tip off around 30 minutes in. So if we have a lot of questions, I'd rather answer questions since you're going to get my PowerPoint later anyway. I'd rather address things that are on your mind than just talking at you. So what constitutes domestic violence? I mean, domestic violence, people often think that it just covers physical violence, but it actually covers a whole host of behaviors that have to do with power and control, including harassment, economic isolation, name calling, kidnapping. It can include assault and battery, physical injuries, but also psychological intimidation and things like that. Manipulation, humiliation, name calling, people following you from room to room, stealing your car keys, your cell phone, blocking you from leaving the house, blocking your car in the driveway. There's a whole host of behaviors that constitute domestic violence. And the word violence is sort of a misnomer because people often think that's physical violence, and it really can be much, much more. This circle is what we call the cycle of domestic violence. And it does show all the various ways that people do commit acts of domestic violence using coercion and threats, intimidation, economic abuse, emotional abuse, isolation, and so forth. And often what happens is there's an act of domestic violence, there is an incident, then there is a apology phase, then there is a wooing back into the relationship phase, the promising of never doing it again. You believe them, and then another act occurs, and this cycle continues on, and it takes victims on average 9 incidents before they actively seek help. Domestic violence statistics, excuse me, are pretty horrific in the country. 24 people a minute are victims of violence of some kind or another, including rape, physical violence, and stalking. 3 in 10 women, so a third of all women, have experienced rape, physical violence, or stalking. And 1 in 10 men. Men are not excluded from being victims of domestic violence. And then even worse is this statistic for psychological harm, which is 50%. So these are real statistics, and it is a daunting social issue facing our country and our state. In 1991, the New Jersey legislature passed what we call the Prevention of Domestic Violence Act, and they found that domestic violence is a serious crime against society. It used to be, the police would show up at your house, they'd tell the abuser, go take a walk. Before 1991, no longer. Now, if there's any sign of physical violence at all, any obvious injury to either party, there has to be a mandatory arrest. Police are much more savvy about these issues now. They have specialized training in nearly every police department in the state of New Jersey to recognize signs of violence, domestic violence, and to prevent it. Now, when I use the word violence in this webinar, know that, again, I'm not talking just about physical violence, but I'm talking about all the other types of domestic violence that come under the umbrella of the statute, which includes non-physical violence, harassment, stalking, kidnapping, and things like that. In New Jersey, the law requires you to have a qualifying relationship before you can seek prevention, before you can seek protection, and you have to have been in a dating relationship either in the past or in the present. It doesn't matter gender. Even if you didn't have a dating relationship, but you have a child in common, or you could be pregnant with the child, you qualify for protection if you need it. Obviously, if you were married to the person or are married to the person, and also includes anybody that you live with. So you may not even be in a relationship with them, but you have cohabited with them even in the past. So if you qualify under one of these categories, then you can seek protection if you need it. What's this temporary restraining order? How do you get it? What's a predicate act of domestic violence? And why do we have to talk about prior history? TRO is temporary restraining order. It is an order of protection. It's granted what we call in lawyer land ex parte. It simply means that you can get a TRO by yourself, apart from your abuser. You can go to the judge, a court, you can go to your police station and get a TRO. You don't have to have the abuser there. Well, you don't want the abuser there, but you can do it without the abuser being present. That's what we mean by ex parte. You fill out an application, an affidavit. This is how you get a TRO. You get on the phone with a judge, or you may appear personally before a judge. We're not doing that in COVID time, obviously, because the courts are closed to the public. But you would get on the phone with a judge at the police station, and they would hear your affidavit, your testimony, and they would grant or deny you a temporary restraining order. The bar is very low to get one. To get a TRO, it's very low. You do have to establish what we call a predicate act, meaning there has to be some incident that falls within the statutory definition of domestic violence, which in the most common act of domestic violence is harassment. So you have to show that on some day, today, for example, this person committed an act of harassment against you. That's what we call the predicate act. That's the defining act that gives rise to your right to seek protection. And you have to, at trial, we're going to talk about that later, you have to prove that that act occurred and what the standard of proof is and the evidence that you need to introduce in order to prove that that predicate act occurred. But also very important in domestic violence legal situations is whether there's a history of domestic violence. Why is that important? Because if you have a relatively, for example, benign incident of harassment as a predicate act, if you have a long history of inappropriate behavior by your abuser, harassing communications, or even physical violence in the past, the court is required to consider the history in the context of the current predicate act to decide whether you need protection. So even a relatively benign predicate act or current incident can give rise to a protective order if there is a sufficient history of domestic violence. And that is one of the mandatory considerations a court has to evaluate. And a TRO is temporary. It just lasts for a few weeks. Actually, the statute says you have to go to a trial and either prove your need for a final restraining order in 10 days. Most of the time, that date gets adjourned. We call it adjourned. That means pushed off into the future. But the statute does talk about a 10-day window where you then have to go before a court to prove your right to a final restraining order. All right, let's talk about final restraining orders. What are they? How do you get one? What relief or what remedies can you get if you have a final restraining order? How long does it last? What are the consequences? And so on. A FRO is simply final restraining order. How do you get one? You got to go to court and get one, meaning you have to testify. Now we are having final restraining order trials by video conference, just like we're doing right now. You present evidence, you can have witnesses, you can introduce documentary evidence. You have to go first. You have to testify about your need for a final restraining order. The abuser or their attorney gets to cross-examine you. The abuser has the opportunity to testify. They don't have to testify. You can present witnesses, like I said. What relief can you be granted under an FRO? You can be granted an order of protection, barring the abuser from having any contact or communication with you, barring your abuser from having any contact or communication with other people in your family, perhaps your children. Other relief can be economic support, can be a bar against owning any weapons, can require the abuser to have what we call anger management training, psychological testing, risk assessment. So there's a whole panoply of remedies that are available to you if you qualify for a final restraining order that you can ask the judge to enter against your abuser. FROs are permanent. They last forever. That's what we mean by final. They don't go away. They don't expire. They don't terminate. They last forever. The consequences of an FRO is that they really, what we mean by consequences is what happens if somebody violates them. And that is a mandatory arrest by of the abuser. And 3 strikes you're out. So if you've violated a restraining order at least 3 times, you're going to jail. This is a much better scenario than going to a judge and asking a judge to protect you every time somebody assaults you or harasses you. This way, the police are involved. You don't need a lawyer, and the police will enforce the final restraining order. How does an FRO affect other family court litigation? If there's custody involved, it can give you some leverage because obviously abusers are criticized, and that does affect their ability to parent properly, especially if children have been witness to domestic violence in your home. It can give the victim a leg up in the family court litigation. So it is important. That is an important consideration especially if you're a defendant. What happens at the trial? Well, you are going to, at that point, have the TRO. It's been granted to you and the defendant has been served. Now you're going to prepare your case. You're going to work with your attorney, or you can do this on your own. You're going to have to prepare your testimony, what evidence is going to be introduced, what witnesses you may want to call. Then the parties present their case at trial. The victim goes first. The abuser or their attorney gets to cross-examine you. Then the victim can present other evidence, documentary evidence. Police can come in and testify. Other witnesses can testify on behalf of the victim, as long as they have personal knowledge of either the history of domestic violence or the predicate act. They have to have seen or heard inappropriate behavior between the parties. It can't be what you told them happened. So the parties present their case at trial, then the defendant goes. They get to testify. They don't have to, but they can. You can cross-examine them, or your lawyer can cross-examine them. They can also present physical evidence, documentary evidence. They can also present police testimony if police were involved. They can also present witness testimony if witnesses were personally observing the incidents, either the predicate act or the history. And then the judge decides whether to grant a final restraining order or dismiss. That's the only thing that can happen at a final restraining order trial, is granting an FRO or dismissing. How does the judge decide whether or not to grant an FRO? There's what we call a three-prong test. That means the judge has to determine three different things. And the case law on that is Silver versus Silver. So the first thing the court has to decide is, do they have jurisdiction? That means, do you qualify as one of those qualifying relationships? Do you come under the umbrella of people that are protected by the New Jersey Prevention of Domestic Violence Act? Also, the jurisdiction also goes to whether the defendant was properly served. You're not going to have a trial if they weren't served. So that's really sort of a mundane issue. Second thing the court has to decide is, did the defendant commit a predicate act of domestic violence? So, for example, for harassment is the most common form of domestic violence. You have to show that the act occurred of harassment. What could be harassment? It could be following you, texting you hundreds of texts, calling you or texting you at what we call inconvenient hours in the middle of the night, not leaving you alone, name calling, following you from room to room. Once you've established something like that happened, you also have to prove that the defendant intended to annoy you by doing those things. Well, how do you prove intent? It's not easy to prove intent, but it can be done. We do it all the time. And you do it by showing that it was the defendant's design by texting you to change your behavior, that it was the defendant's design by calling you to get you to respond to them. See, domestic violence is all about power and control. So when I ask a defendant on cross-examination, what did you want, let's say, Susie to do when you texted her 100 times? Oh, I wanted her to call me back. I wanted her to stop doing what she was doing. Exactly. That's intention. And that's all you need to do to show, for example, that the abuser committed an act of domestic violence called harassment and had an intention by doing that act to annoy you or to get you to change what you were doing or do something that they wanted you to do. And then the third prong is, do you need protection in the future? Do you need this final restraining order to stop future acts of domestic violence? And the way a court evaluates this third prong is by, remember the history, it's by looking at the history, because the best predictor of future behavior is what's happened in the past. And if this abuser has been demonstrated by your testimony of history of violence in your home, that they commit acts of domestic violence against you and have done that in the past, then they're more likely to do it in the future, and you will qualify under the third prong. You don't need a history. For example, if you have a really egregious predicate act, a serious physical assault, you don't need a history, because there's case law that says serious physical harm, it's just perfunctory that you're going to get a final restraining order. The fact that you were beaten and have physical injuries You don't need to intention is implied, and you don't need to show a history. History becomes more important when you have those invisible forms of violence, like harassment, which is really insidious abuse because there's no signs of physical harm. And that, of course, is the Silver versus Silver case that identified those three tests. What's domestic contretemps? This comes up in divorce court all the time, because when you're getting divorced, things kind of unravel at home. They can. And bickering, fighting doesn't qualify. That's what the court calls domestic contretemps, that French word that means domestic conflict, marital conflict. A little bit of name calling and crappy, let's say, behavior in the home. That's not what we're talking about. We're talking about ongoing abusive marginalization or actual physical harm. Domestic contretemps does not qualify for protection, and it's considered a sort of normal part of the divorce behavior that may take place. But if you're not sure, confer with an attorney about what's going on in your home so they can help you identify whether it is domestic contretemps or domestic violence. We talked a little bit about harassment, which is, again, the most frequent form of domestic violence. And here's some of the criteria for harassment. There has to be a purpose to harass. Like I said, anything that's communicated to you anonymously or at extremely inconvenient hours can qualify for harassment. Offensively coarse language, that's name calling. Using language, that threatens to harm you, kill you, harm your family, anything like that, that's designed to scare you. And then, of course, any kind of physical touching would also not just be considered assault or battery, but also a form of harassment. And then also this most important one, engaging in a course of conduct. So remember what I said earlier, that predicate act might be relatively benign. It's not so bad, but when you put it together with a history and a course of conduct that is repeated and chronic, that in total, in context, can be considered harassment. What's the burden of proof in a domestic violence trial? It's a preponderance of the evidence. What that means is it's more likely than not. So you ever watch Perry Mason? Maybe you're too young to have watched Perry Mason, but criminal trial, that's beyond a reasonable doubt. That means that there is no scintilla of doubt in your mind that the defendant did not do these acts. That's not what the burden of proof is, much less in a domestic violence trial, as it should be, because there is often an inability to prove beyond a reasonable doubt, because there could be no witnesses, you could have no physical injuries. So the burden of proof is lower, and it's what we call preponderance of the evidence. It's more likely than not that these things that you've complained of have really happened. What can happen at the first court appearance? There's really only three things that can happen. You either change your mind and dismiss, which you're going to get counseling if you go to court before dismissal. They will always require you to have domestic violence counseling from a person that works for one of the domestic violence agencies in the county in which you're appearing, to make sure you understand the cycle of domestic violence and that you understand what you're doing, that you can always come back to court if there's future acts of violence, but that you're doing this knowingly, you're not being pressured in any way. So that's the first thing you could do when you go to court for the first time for your case. You could just change your mind and dismiss, but that means that your abuser is coming home. That means that your abuser can communicate with you with impunity. The second thing that could happen is you can have a trial. That means you're going to have to give testimony. And then the third thing is you can request an adjournment, which means push off the date. Maybe the defendant or plaintiff shows up with a lawyer and you don't have a lawyer. And you're like, okay, I'm a little scared. I don't want to have to deal with the lawyer on my own. I want to get a lawyer now. I need to get an adjournment from the court. That will be granted to you for you to have an opportunity to get a lawyer. So presenting your case for a final restraining order, you have to prepare your testimony and be prepared to talk about what happened that gave rise to you seeking protection from the court. We call that the predicate act. And you're also going to have to testify about the history and why you need protection. You're going to need to prepare your witnesses, cross-examination of the other party. You're going to want to gather evidence. For example, text messages, emails that you may have received. I recently did a trial where there was a lot of physical evidence. Things were broken in the home. We actually brought them into the courtroom. We had pictures of holes in the wall that were created by the abuser. All of that evidence has to be gathered and what we call authenticated, means somebody has to testify to the court that this is actually what it purports to be and that it hasn't been tampered with since the evidence was created. Of course, you want to dress appropriately and be respectful at all times, even if you disagree with what's being said. If you're defendant, there's some strategies that we can talk to you to counsel you about, and if you are being accused of an act of domestic violence. For one thing, you want to determine if should you file a cross TRO, meaning if you're a defendant being accused of an act of abuse, was there a mutual fight that would give rise to you being entitled to an order of protection against the person accusing you? We call that a cross TRO or a cross application. If the incident was provoked and and what you did was self-defense, we want to determine that and be able to present that evidence to the court. What other evidence might there be that the court should know about that weigh against granting a final restraining order? And that may go to the credibility of the victim. And there's lots of ways that we can work with you to determine how best to discredit their testimony. You always want to meet the allegations, though, head on. You don't want to tiptoe around them. You want to explain your version of the events. It's interesting because two people can be experiencing the same event and have very different perceptions of what transpired in that moment. And your testimony is going to matter, and you're going to have to be prepared to talk about what happened from your viewpoint. And sometimes, honestly, these things don't give rise to a need for a final restraining order. They're overblown. And again, whenever you're a witness or going to court, you want to be dressed properly and always act respectfully towards the parties and the judge. Okay, so you're getting ready to present your testimony. The first thing that happens is the victim goes first, and that when they tell their story, whether they have a lawyer or not, is what we call direct testimony. And after they're done testifying, then they're subject to cross-examination. This is where the victim tells their story. The defendant's also going to get an opportunity to give what we call direct testimony and tell their side of the story. And then the victim's attorney or the victim themselves will have an opportunity to cross-examine the abuser, alleged abuser. Cross-examination. Everybody's always afraid of cross-examination. Of course, you want to stay calm. It's easier said than done. But here's what I tell people. Because everybody wants to know what they should say. What are the words that I can give you to say when you're being cross-examined? The best advice that I give my clients' witnesses that have to be cross-examined is to always speak from your heart. What do I mean by that? You know what happened. You were there. You may not remember the exact words being said or the sequence of events, but in your heart, there was something happening. And if you speak from your heart and rely upon what you know to be true, your chances are it's going to come out sounding truthful, sounding genuine, and sounding believable. You always, on cross-examination, only want to answer the question posed to you. You don't want to go giving a long, drawn-out story or explanation. It just opens you up to further attack. A question is asked of you, just answer that question. And a good lawyer on your side who's watching you be cross-examined by the other lawyer is going to protect you and make sure that you're only answering the questions that are posed to you.
Roseanne?
Yeah.
This is Kate. I just wanted to let you know that it is 9:30, so
Okay.
we're about halfway through. We don't have any questions yet, so I wanted to remind the audience to feel free to send in some questions if you have them, and I'll go ahead and read them when we get to the Q&A portion. Thank you.
Great. All right, you're welcome. Thank you for the interruption. Okay, so witnesses. Who's a good witness? Again, witnesses have to have personal knowledge. You can't have your best friend testify what you told them happened 3 days ago because they don't have personal knowledge. They weren't there. They didn't observe it with their eyes or hear it with their ears. They have to have personally seen something happen, or they could be on the phone and hear it in the background, something happening. The only exception to that rule is where something happens really serious and you contact somebody right away and your demeanor is very upset. The witness could testify about your demeanor. They can't testify about what happened because they didn't hear it, they didn't see it, but they can testify about how you were acting, which is probative of something happening to you that may be relevant. And again, what can the witness testify about? Only what they saw, only what they heard, only the predicate act, and only about the history. No witness, either the victim or the abuser or any witness either side presents, can testify about anything that's not shown on the what we call complaint as a predicate act or a part of the history. So if you leave something out and you remember at trial another incident, you're not allowed to testify about that because it's not in the complaint. And the constitutional rights of the defendant mandate that they get notice of anything you claim against them. But that's not the end of the story. You do have the right to amend your TRO at any time. So if you forget something, you can add it, and then the case will be pushed off to the next cycle so that you have time to do that, and then the defendant would get notice of that additional claim. Common objections. So when you're in a trial, there are objections raised by your lawyer or by the other lawyer about what's being presented. These are some of the common objections that you may hear in a trial. Relevance of the answer or the question. What does that mean? It means that what's being asked of you has to be probative of the predicate act or the history. What you had for lunch on the day of the incident is not relevant to whether this defendant committed an act of domestic violence. What happened 3 days before when you were driving to the beach for the day is probably also not relevant to whether this defendant committed an act of domestic violence. Lack of personal knowledge. I kind of alluded to that when we talked about witnesses. People can only testify about what they have personal knowledge of. Personal knowledge means they saw it or they heard it. Improper character evidence. You can't prove somebody committed an act of domestic violence by showing that they were a bad person in the past, or maybe they have another final restraining order against them from another victim. It's not probative of whether this defendant committed an act of domestic violence in this case. So that is very prejudicial testimony, and it does not come in. And I'm not going to go through the other objections, but there they are, except for hearsay. Hearsay is when you testify about something somebody told you, and whatever the something is, you're offering it for the truth of the matter asserted. Okay, what does all that mumbo jumbo mean? You can always testify as to what the abuser said to you. The abuser can always testify as to what the victim said to them. But let's say the police were called to your home on the day of this incident, and the police separated you, and you're in the kitchen, and the police officer said things to you. You cannot testify in trial about what the police said to you. Only the police can do that. Why? It's considered hearsay. It's not reliable. The best evidence of what the police officer said to you is going to come from the police officer, not from you reporting and repeating what they said, because there's no way for a judge to test the credibility or accuracy of what the police officer said to you because the police officer isn't there. You're the one testifying what the police officer said. So it's inherently unreliable testimony. you won't get to introduce it. But you can bring the copy. Interestingly enough, police reports are hearsay. So people often think, oh, I'll just get the police report and that's going to show what happened. But all these statements in a police report are hearsay. So they do not come in unless you have the live testimony of the police officer that wrote the report. The report is evidentiary. It may come in if the police officer can authenticate it, but it doesn't need to come in because the best evidence of what happened on this event is the police officer's personal observations and reporting of what you told them. Now, they can testify as to what you told them. That's an exception to the hearsay rule. All right, other evidence, documents, emails, photographs, text messages, call logs, all this stuff can come in as long as it's properly authenticated and properly presented. And your lawyer will work with you to help you do that. Text messages have to be printed out. You know, obviously, even when we could go to court in person, you can't show text messages from your phone. Why? Because the other side has to be looking at the same thing you're testifying to, and so does the judge. So if you think about it in there's three groups of people in the courtroom, whether it's virtual or in person. There's the victims camp, there's the abusers camp, there's the judges camp. All three have to have the evidence in front of them that you're talking about. So things have to be printed out. They have to be marked. We call it marked with exhibit identification information, including text messages. And as you present that evidence, you go through it and everybody's looking at the same thing. Call logs would be from a cell phone. Let's say you want to testify, this person called you 40 times yesterday. You could get that call log. You go to your Verizon or AT&T account and you can actually print the call log out, and that can be authenticated by you. What do I mean? I keep saying this word, authenticating evidence. What does that mean? That means that you're establishing that the evidence is reliable and accurate. So for example, let's say you want to present a photograph of an injury, a bruise on your arm. Well, sometimes it could be weeks before you actually go to trial, and so the bruise is now gone. But the day it happened, you took a picture. Somebody took a picture. Whoever took that picture has to be in the courthouse or on the Zoom or webinar or WebEx to testify that they took the picture and that they didn't do anything to doctor or change or alter that photograph. That's what we call authenticating. So we always require our victims, if you will, to take their own photographs, because then you can authenticate them. I took this photograph of my arm. I didn't change it. I didn't edit it in any way. I just printed it out from my phone. Same thing with photographs that you may take of things in the house, or I once had a computer that was thrown off a balcony and it smashed, and then somebody picked it up and moved it into the garage, like tried to clean it up, and there was a big brouhaha about whether that had been damaged again or further between the time it had landed on the foyer floor and moved to the garage. And so the parties themselves were able to authenticate, the victim in this case was able to authenticate that the computer had not been altered from the time it hit the floor to the time it had been moved to the garage. But that's what authentication is. Credibility is everything. I've had a number of cases where, I'll tell you a quick story since I don't have a lot of questions. I think I have time. I'll tell you a quick story. So I represented a defendant in a domestic violence action. He was accused by his wife of choking her in the kitchen. And every time I asked him to repeat to me the blow by blow, the minute by minute event that happened on that day, he told me the same story. I must have asked him 6 times. In fact, I had my associate, a young lawyer, interview him as well, because I wanted to see if he told her the same story, and he did. So I thought, okay, this guy's telling the truth. And his claim was that he did not choke his wife, but that she attacked him and he pushed her right near her shoulder blades, pushed her away. It was not a choke, it was a push. So We get to court. This was in person. We get to court, and he's being cross-examined by the wife's attorney. And the judge interrupts, and they're allowed to do this, and says to him, "Sir, how long were your hands near your wife's neck?" And he says, "I don't know." She says, "Well, was it a minute, 2 minutes, 5 seconds?" And he's like, "Oh, about 40 seconds." And I thought, oh, 40 seconds is not a push. 40 seconds is a choke. So you see, credibility is everything. And being honest is something you can't fake. You can't fake being honest. And if you truly have done something that's considered domestic violence, you're better off trying to make a deal with the victim, an alternative resolution, than having your credibility destroyed at a trial. What happens if the court grants the FRO? So there's a bunch of stuff that can happen. And most importantly is the restraints, which is the bars, barring the abuser from having any contact or communication with you or your loved ones, or children, in fact, can be included within the prohibitions against them coming to your house, granting possession of a home. It can also include barring them from coming to your places of employment. Protected parties would be people that also need protection that are related to you, like children or parents or siblings. Exclusive possession of the home would be granted usually to the victim. Custody of children can also be addressed when a court grants a final restraining order. Parenting time can also be addressed. Most of the time, if somebody is granted a final restraining order, that the abuser is not going to be given unsupervised parenting time, depending on how egregious the domestic violence was. And there are agencies that will help you will handle the supervision of the children so that the defendant can have contact with them. We can also include financial support, because if you are not only a victim but also dependent financially on the defendant, we can make sure that there's some support coming in until we can address this financial issues on a more global basis. Of course, weapons are seized. This is mandated by the statute. Anybody with weapons is going to lose them if they've committed an act of domestic violence. The actual forfeiture proceeding is a separate proceeding. It takes place in the criminal courts, and that is handled by the prosecutor in the county in which the weapons are seized. But abusers typically cannot own weapons. They'll lose their right to have a firearms ID card, and they actually lose possession of the actual weapons. And you can also get restitution and have your counsel fees paid and out-of-pocket costs. So for example, if you lose wages because you had to go to trial and get a final restraining order and you couldn't get paid for that, you can actually recover that as damages against the defendant. You can also recover your counsel fees. Counsel fees are mandatory. It's not discretionary on the part of the court at all. You will get your counsel fees if a final restraining order is entered against the defendant, as well as your lost wages or any other out-of-pocket costs, like if the defendant broke something or damaged an item of personal property, that can also be recovered. And then evaluation. So sometimes if you're just leaving the relationship and the final restraining order is going to sever the relationship and there's no kids involved, you might not care about evaluations. But if there's kids involved, you definitely want evaluations to be conducted on the defendant. They could be psychological evaluations, risk assessments, anger management training, substance abuse evaluations. It just depends on the circumstances what we're going to ask the court to do for you to protect you and make sure that the defendant is fit to have contact with the child. And,
Roseanne?
Yeah.
Sorry to interrupt again. We do have a few questions rolling in.
All right, let's go.
So okay, great. The first one is, if an employee comes to an employer sharing that they are in a domestic violence situation, what is the responsibility of the employer other than complying with state laws to give time off to deal with issues?
I don't think they have any. I don't do a lot of employment law. I don't do any, but I don't think they have any responsibility to report or anything like that. Schools would. So if children are witness to domestic violence and police come and see that the child was present during this altercation, for example, they would have an obligation to report to DCPP. Or if a child went to school and said, this is happening at home, the guidance counselor or teacher would have an obligation to report. But I don't think an employer has any obligation to report if that's what they're asking. And they do have to give you time off, but they don't have to pay you, and that's part of
Okay.
the.
Okay.
Is there
Sure.
another question?
Can children be witnesses in court? Perhaps. Yep. Can children be witnesses? Perhaps age matters. I'm thinking that she means in court.
Yeah. We discourage children as witnesses, and it depends on the circumstances. We have done that, but it's very rare. Judges hate it. It's very bad for the children. The children are not emotionally mature to understand what's happening, and it polarizes them. But there are circumstances where maybe it's the only way to achieve the protection that you need. Now, older children, that may be a different story. 15, 16. We did have a 12-year-old testify on behalf of the mother victim, where she actually witnessed the physical assault because the father, just testified and denied that any of it ever happened. But that is very rare. Is it permitted? Yes. Do we, as a matter of policy, do it? We try to avoid it at all costs because it is terrible for the kids to be dragged into court to testify against their other parent. It's just bad for the child. It's not in the child's best interest. But sometimes you have no choice, and we will weigh that carefully.
Makes sense. Next question. Public perception is that domestic violence has risen during the pandemic. Is that substantiated? Has there been an increase of TROs, police calls, etc., since March compared to previous years?
Not in the early parts of COVID, but now, June and July, it's exploded. There has a reported increase in domestic violence during COVID because the lockdown precipitates inappropriate behavior because there's nowhere to go, and you're sort of stuck in the house with your abuser. I can tell you just personally, I right now I didn't have any domestic violence cases between March and May. Since the middle of June, I have 4. And that's just me. There's other lawyers in my firm that are also handling domestic violence cases. And remember, they're short, what we call summary proceedings, so that the act occurs and within a couple of weeks you're going to trial. So these are 4 relatively recent incidents, and there's probably another 4 in my firm, so a total of 8 that we're handling since the middle of June. So yes, it's really, there's been an explosion of domestic violence behavior and court appearances.
Thank you. Next question. A restraining order was in place in the late 90s. The person moved away. The order was then canceled by the victim. Years later, the assailant has made verbal threats. Will the victim need to request a new complaint? And will the prior 90s restraint be considered by the judge or dismissed as past evidence?
Yes, you need to do another application for a temporary restraining order and it will absolutely be considered what happened in the past. It will not be discounted or dismissed. So there could be a relatively benign current incident, like a veiled threat, but when coupled with that prior incidence or history, can give rise to a final restraining order because the court is mandated to consider the history, all history, even ancient history, if it's a while ago.
Excellent. Next question. With the lack of in-person trials and as we adapt to life with COVID, do you have any recommendations to address this issue? What improvements are needed through the courts, law enforcement, children at home with remote learning, etc.?
You mean in presenting a case remotely, or I'm not sure I understand the question.
I'm not sure I do either, but perhaps she will send a follow-up. I think it sounds like recommendations to address the issue in general, but
Okay.
maybe improvements through the court.
Yeah. So the trials are taking place. We submit evidence in advance. It's no different. It's a little different, obviously, because demeanor is a little harder to read by a judge when witnessing testimony on a screen. But we do it, and it's happening every day. If you were asking the other question, which is sort of how do we prevent this rise of domestic violence given COVID, really the best recommendation I can give to people that feel they may be a victim is to get help. In every county in the state of New Jersey, there is an agency that will offer you help, either free or on a sliding scale. It's anonymous help. You can get help. They will teach you about the cycle of domestic violence. They will teach you how to stay safe in your home. They will provide police and counseling and other resources to you if you want to leave the home, or if you want to get a restraining order against your abuser that you're in the home with. There's shelters, there's long and short-term housing options available to you. If you're worried about going to a local agencies, there's the national hotline that you can call. There's tons of educational information out there on the web. We have done other webinars on domestic violence and have downloadable tools on our website that can help you understand what you're experiencing. But if you feel like you're a victim or experiencing this in your home, then you've got to try to get some help. And especially if you have kids in the home, it's actually considered a form of abuse and neglect for your kids to chronically witness domestic violence. I don't know if anybody remembers the Nazi father. It's actually from Hunterdon County, and he lost his parental rights over the fact that his children were chronically witness to him committing acts of domestic violence against the mother. They didn't harm the children specifically. They didn't physically assault the children. The children were well fed, but the fact of them being witness to the violence caused the state to terminate their parental rights. So if your children are witness to domestic violence, that also needs to be addressed. And most agencies have resources for kids. But that is something you really need to think about. Do you want DCPP in your life? Because maybe your kid goes to school or tells his friend's mommy that this is happening in your home. Then you have DCPP in your life, and that can be very, very daunting and troublesome, and potentially interfere with your parental rights because you're not doing anything to protect them.
Thank you.
I don't know if that answers your questions, but.
Definitely. Next question, is there a statute of limitations on these cases if there is contact from the abuser over 20 years later? No TRO was obtained previously.
So if it's been 20 years since the last, historical act, and the current, let's say, we'll call it a predicate act, is really benign, it's going to be difficult. But it depends on how troublesome or scary or annoying the history was. So if the history is really egregious and includes a lot of physical violence, a very benign predicate act or current act can still give rise to protection. It just depends on the facts. You don't have to have gotten an order of protection 20 years ago. 20 years later, this person resurfaces and it's sort of benign, but what they did in the past was really scary. Go get some help. Go to the agency. Talk to a counselor. Get a complimentary consultation with an attorney. They can evaluate that for you.
Okay, and we don't have any additional questions, but I have a follow-up question. The Nazi father in Hunterdon County, leaving aside the Nazi part, could the victim be held accountable for not seeking protection if her children are witness? Could that interfere with her parental rights as well? Wow.
Both parents lost custody and their parental rights were terminated. Both parents.
Wow.
They lost custody of their children because they did nothing. The mother was being abused and she needed protection. She never sought protection for herself, but the chronic witnessing gave rise to DCPP coming in and filing what we call a complaint for abuse and neglect, and both of them lost custody of their children permanently.
Okay, one more question came in. Are all consultations with an attorney free, or does it depend on the attorney?
That definitely depends on the attorney. We do offer complimentary consultations, so At the end of the slides, you'll see our contact information, so you can call our office and we'll give you a complimentary consultation. We're doing them, I'm not doing them in person because I live with a high-risk individual, but we'll do it by Zoom video conference just like this, or we'll do it by phone. But I have other lawyers that would see you if you prefer to be seen in person.
Excellent. So that is the end of the questions. I don't know if you have a few more slides that you want to wrap up.
Yeah, let me see what I have here. So what happens if the court denies the FRO? It would be dismissed. Everything goes back to the way it was. But if there's a new act of domestic violence, make sure that you get another TRO. Custody considerations in domestic violence cases, that would of the home, having the abuser removed, but not actually going to trial. So that is an alternative. And then that was really it. Parting thoughts: make yourself a priority, create a safety plan, practice self-care, reach out for help. The next slide does show all the various resources that are out there. We can certainly help you if you have a domestic violence related inquiry. There's a statewide domestic violence hotline. There's a national domestic violence hotline. One of the best domestic violence agencies in the state of New Jersey is in Morris County. It's called JBWS, but every county has an agency that you can call upon to help you. So that is my presentation. I'm happy to give we have the slides available. I know Kate mentioned that, and I thank you so much for your time today. I really appreciate you being here.
Thank you so much. Yes, as Roseanne mentioned, the slides and the recording will be emailed to you tomorrow. When you close out of the webinar, a survey will come up on your screen. We hope you will fill it out so that we can better understand how to provide you more important feedback, more important information in webinar format. Our next webinar, Succession for the New Decade, Why Today is the Best Time to Reduce Your Cost of Succession, will take place later today, July 23rd at 2:30 p.m. So by all means, feel free to register for that. And don't forget to check out Domain Computer Services for all your IT needs and at godomain.com, pardon me. Until next time, for Roseanne DeTorres of DeTorres and DeGeorge Family Law, this is Kate Conroy, thanking you for being with us today and wishing you a great day.
Thank you so much. Bye-bye.